Good morning, everyone. The webinar will begin shortly. Good morning, everyone. My name is Jeffrey Salant. I am the HOA Information Officer for the Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. This morning, we are going to talk about what the Colorado Common Interest Ownership Act, also known as CCIOA or CIOA, says about maintenance and insurance. In addition to the insurance obligations placed upon the association, we will also discuss maintenance of the common interest community. There are 4 handouts attached to this webinar: a PDF of this presentation, a PDF copy of HOA Insurance 101, presented by Ms. Ella Washington of American Family Insurance, a copy of CIOA, and a copy of the Colorado Nonprofit Act. You may download them by clicking on the blue links located under the Handouts tab on the GoToWebinar control panel. This webinar will be recorded and uploaded to YouTube. Once available, you may access it via the link to the division's YouTube channel on the PDF handout of this presentation in the second to last slide. Please note that the information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. Before we get into the presentation topics, I would like to take a few minutes to talk to you about my office, the HOA Information and Resource Center, and show you some of our website. We've recently redesigned and improved our website so that it is easier for you to find what you are looking for. This is the main landing page when you visit dre.colorado.gov/HOA-center. There are 6 main areas. The 6 main areas are register your HOA, HOA forums, file a complaint, board member education, homeowner toolkit, and resources. On the registration page, you will find general information regarding the registration and renewal of HOAs. There's also a troubleshooting and resource section below. On the HOA forums page, you will find information regarding upcoming forums and links to register for them. You may click on one of the graphics for an upcoming forum, and it will take you to the registration link. On the File a Complaint page, you may find resources to file a complaint with my office. Although the HOA Information and Resource Center, as well as the Division of Real Estate, lack any investigative or enforcement capabilities to address HOA complaints, we do record your issues and matters of concern into a statistical database, which is later compiled into an annual report that the state legislature may use to help determine future legislation regarding HOAs. In my opinion, the board member education page is arguably the most valuable of all of our pages. It contains 16 videos addressing everything from elections to association records, handling disputes, roles and responsibilities of board members, as well as budgeting, assessments, and collections. Very useful page. The Homeowner Toolkit page includes some great resources for those who are considering purchasing a home in an HOA, including literature on what to expect, as well as some previously put on presentations which touch on some basic HOA issues. Finally, the resources section of the HOA Information and Resource Center contains a library of resources of previously published information from my office. There is a search function right down here where you can search for a specific keyword. You want to learn about meetings, you type meetings, and you got some great information that pulls up. The HOA office is a statutorily created office, and my position, the HOA Information Officer, is appointed by the Director of the Division of Real Estate. Per statute, the HOA office provides information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Ownership Act. It gathers, analyzes, and reports information through complaints and HOA registrations, and creates an annual report which is delivered to the legislature. It creates resource materials, provides education, and also presents HOA forms. In addition, it maintains a website with information for the public, and it registers HOAs. The HOA office does not act as a regulatory program. It does not mediate or arbitrate. It cannot provide legal advice, does not act as an advocate, cannot assess fines or penalties, and does not enforce an HOA's failure to register. Today's presentation will go over the requirements in CCIOA regarding maintenance duties and insurance requirements. While we will be discussing the requirements of each of these concepts, the division is unable to provide a specific breakdown of the insurance policies needed for your specific community. However, if you would like some more detailed information about HOA insurance, please take a look at HOA Insurance 101, a previous presentation of the HOA Information and Resource Center presented by Ms. Ella Washington of American Family Insurance. This is available under the Handouts tab on the GoToWebinar control panel. Utilizing robust maintenance schedules and performing quick and quality repairs is essential to reducing insurance claims. When something does go wrong in a common interest community and repair or maintenance is needed, who is responsible? The association or the homeowner? Under CCIOA, unless there is a statement to the contrary in the declaration, the association is responsible for the maintenance, repair, and replacement of the common elements of the association, which includes both the general and limited common elements. And it is the owner's responsibility for the maintenance, repair, and replacement of such owner's unit. Additionally, each unit owner must provide the association and the other unit owners and their agents or employees access through such owner's unit reasonably necessary for those purposes. This type of access would be typical in condominium communities. If damage is inflicted, or a strong likelihood exists that it will be inflicted on the common elements or any unit through which access is taken, the unit owner responsible for the damage or expense to avoid damage, or the association, if it is responsible, is liable for the cost of repair. Generally, A homeowner is responsible for maintaining anything within their home unit. However, the board has a responsibility to review the declarations and covenants for guidance and a determination of who has the responsibility for maintaining the many items in the community, the HOA or the individual homeowners. Maintenance issues for a homeowner is much different in a single-family development versus a condominium community. While the owner of a single-family home is responsible for maintaining their home and the land upon which it sits, a condominium owner is responsible for maintaining the unit inside their building, with the association being responsible for the outside building structure and the community property surrounding it and within the community. A maintenance responsibility chart should be developed and used as a very practical, clear, and preemptive roadmap of maintenance responsibilities. An association can get assistance creating this list by working with their legal counsel and insurance agent. An added benefit of having this chart available is that it will help the board make better decisions for the association and avoid unnecessary requests for repairs that are not the responsibility of the association. In the same light, it will be clear for homeowners to not take on the maintenance responsibilities of the association. If there are any maintenance, repair, or replacement of any drainage structure or facilities or other public improvements required by the local governmental entity as a condition of development of the common interest community, that shall be the responsibility of the association, unless such improvements have been dedicated to and accepted by the local governmental entity, or replacement has been authorized by law to be performed by a special district or other municipal or quasi-municipal entity. The declarant is the developer of the subdivision, and the association was created for its benefit. In some instances, the declarant may still be in control of the homeowners association. In that case, the declarant alone is liable for all expenses in connection with real estate within the common interest community, subject to development rights. No other unit owner and no other portion of the common interest community is subject to a claim for payment of those expenses. Unless the declaration provides otherwise, any income or proceeds from a real estate subject to development rights inures to the declarant. If the declarant fails to pay all expenses in connection with real estate within the common interest community subject to development rights, the association may pay such expenses, and such expenses shall be assessed as a common expense against the real estate subject to development rights, and the association may enforce the assessment pursuant to CCIOA by treating such real estate as if it were a unit. Section 38-33.3-313 of the Colorado Common Interest Ownership Act covers the insurance obligations of the association. According to CCIOA, homeowners associations have an obligation to provide certain insurance. There is both mandatory and optional insurance coverage. Premiums for insurance that the association acquires and other expenses connected with acquiring such insurance are considered common expenses. The association shall maintain, to the extent reasonably available, property insurance on the common elements and, in a planned community, also on the property that must become common elements for broad form covered causes of loss. The total amount of insurance must not be less than the full insurable replacement cost of the insured property less applicable deductibles at the time the insurance is purchased and at each renewal date, exclusive of items normally excluded from property policies. Commercial general liability insurance against claims and liabilities arising in connection with the ownership, existence, use, or management of the common elements, and, in cooperatives, also of all units, in an amount, if any, not less than specified by the common interest community instruments, ensuring the executive board, the owners association, the management agent, and their respective employees, agents, and all persons acting as agents. The insurance policies must provide certain terms under law that have to do with owners' liability, subrogation of claims, voidance of a policy, and issues of primary insurance coverage. These are complicated insurance issues that should be reviewed and discussed with your insurance agent and legal counsel. In addition to the requirements in CCIOA, an association's declaration may require it to carry any other insurance, and the association in any event may carry other insurance it considers appropriate, including insurance on units it is not obligated to insure, to protect the association or the unit owners. If the required insurance coverages are not reasonably available, or if any policy of such insurance is canceled or not renewed without a replacement policy, therefore having been obtained, the association shall promptly cause notice of that fact to all unit owners. When something goes wrong and repair is needed, who is responsible? The association or the homeowner. Under the CCIOA law, unless there is a statement to the contrary in the declaration, the association is responsible for the maintenance, repair, and replacement of the common elements, which includes both the general and limited common elements, and it's the owner's responsibility for the maintenance, repair, and replacement of such owner's unit. Regarding certificates of insurance, an insurer that has insured an insurance policy shall issue insurance certificates to the association and, upon request, to any unit owner or holder of a security interest. Not to be confused with an insurance policy, which is purchased, associations should adopt certain policies regarding the use of insurance. An association may adopt and establish written non-discriminatory policies and procedures for the association. These policies should be related to the submittal of claims, the responsibility for deductibles, and any other matters of claims adjustment. To the extent the association settles claims for damages to real property, it shall have the authority to assess negligent unit owners causing such loss or benefiting from such repair or restoration all deductibles paid by the association. In the event that more than one unit is damaged by a loss, the association, in its reasonable discretion, may assess each unit owner a pro rata share of any deductible paid by the association. Any portion of the common interest community for which insurance is required that is damaged or destroyed must be repaired or replaced promptly by the association, except under limited circumstances. The cost of repair or replacement in excess of insurance proceeds and reserves is considered a common expense. An insurance policy issued to the association does not obviate the need for unit owners to obtain insurance for their own benefit. Owners should have their own insurance policy and it should tie into what the HOA's master insurance policy covers versus the homeowner's personal policy. There should be coordination. Also, there are different homeowner insurance policies depending on the type of unit. For example, single-family home policies will provide significantly different coverage than condominium home policies, which are designed specifically for condo owners. Fidelity Insurance generally covers coverage for the association's operating and reserve funds by protecting against embezzlement, check fraud, invoice padding, false invoices, and computer wire fraud. According to CCIOA, if any unit owner or employee of a HOA with 30 or more units controls or disperses funds of the HOA must maintain, to the extent reasonably available, Fidelity insurance. Coverage of such insurance must not be less than the aggregate than 2 months of current assessments plus reserves, as calculated from the current budget. Additionally, any person employed as an independent contractor by an HOA with 30 or more units for the purposes of managing the HOA must obtain and maintain Fidelity insurance. It must be in an amount not less than the aggregate of 2 months' current assessments plus reserves, again, as calculated from the current budget, unless the HOA names the person as an insured employee in their contract of Fidelity insurance. Finally, the HOA may carry Fidelity insurance in amounts greater than required and may require an independent contractor employed for the purposes of managing the HOA to carry more Fidelity insurance coverage than required.